they assign words associated with certain conditions, and when you have a new condition, you have a new word to cover it, because if you try to use the same words, it's true in both cases, or in one case they were the moving party, in this case where you're appealing, you're a moving party. Well, how do you keep this all straight? Well, it's you sign these words on those levels. There's actually no difference. You get right down to it, there's no difference between an appellant and a plaintiff, because you are suing the lower court in the appellate court. But there's no money penalty, it's just a status thing.
And why would the appellant not be at the top versus the state?
He is at the top. Appellant, in an appeal, it's appellant, the appellant versus the appellee. That's what I thought. Well, who knows, you know. I'll tell you what I did in one case that was kind of fun. We filed a case. All right. There was no case in court at all, and we filed a case where we named the other side as the plaintiff and ourselves as the defendant. Why? Because they had already opened their court. We went on that theory, that they had opened their court. They just hadn't filed the case yet with the court system. But they were prosecuting their case administratively or something like that. But we said, hey, you guys have opened your court. You're obviously the plaintiff. And we're responding, but we're filing right in this, we're putting it right in the court system. We're bringing you right over. You're the plaintiff there. You're going to be the plaintiff here. We're defending against you.
Does that make it there?
You wanted to make your cross complaint, so you had to.
Well, it wasn't exactly a cross complaint. I mean, we were stating our case, but we're the defendants. We're defending against these guys. That's why we filed our case. It was kind of a twist in thinking. They didn't throw the case out.
Oh, did you defend successfully?
I don't remember the outcome, but I probably that person gave up. I mean, a lot of cases don't make it to the end simply because somebody decides not to pursue it. You know, they lose their spirit, their energy or something. That happens a lot.
One other point, Bill, you might want to clear up is that bottom statement there, ruling regarding second contempt in the presence of the court. You might explain the presence of the court.
Yeah, okay. Well, yeah, this is kind of off our subject here, but I guess we're randomizing, right? Since there's no more questions on the form. Well, what happened was there's two categories of contempt. In one category, you have a contempt that occurs right in front of the court. The court's in session, and it happens, whatever it is, whether it's dignity or challenge to authority, it's right there in front of the court. When that happens, the court can do a summary judgment on the spot. Why? Because no testimony is needed. Okay? The court saw everything. There's nothing to be proven to the court. No witnesses are needed because the court saw it itself. Okay? So when Aurora was an order had been delivered from her court, which was a superior court, to their court, which was an inferior court, because they were going according to statutes. So they were under the jurisdiction of the superior court. Then they hauled her in from the jail and they conducted a proceeding in violation of that order. Well, remember, the court travels wherever the sovereign travels. So when they hauled her in, they're also hauling in her court. Okay? So
when she walked in the room, there are simultaneous courts being.
Well, the person and suit of the sovereign. Okay?
Now present.
Right. And it's wherever she travels. Okay? Wherever that may be. So when they forced her, because they kidnapped her, right? They pulled her over into the criminal court and they held their proceeding, and that very same criminal court had been given an order which they were disobeying from her court. So her court's there, she's there, her court's open, and when they disobeyed in front of her, they were in direct contempt of her court. So consequently, we wrote up a contempt and fined the judge and the attorneys that were conducting this proceeding right away. We went straight to summary judgment. Summary decision. Well, they're supposed to know what's happening. I thought these are attorneys at law. Okay?
Why is the bailiff in?
The bailiff is not informed of anything. I mean, he's just a cop. He's just a muscle man, okay?
Keeping the peace. Or whatever.
Operating according to the commands of the judge. I mean, we're not holding him responsible for anything.
Okay.
So we're able to enforce it.
By custom or policy of the sovereign?
Well, it's kind of obvious. He didn't do anything. He's just a hunk of meat standing there, Somebody's got to push the buttons to make the appropriate muscles move. He's not thinking. He's got an IQ of 104. What do you expect? He doesn't read the court papers. He's just sitting there waiting for somebody to go attack. He's an attack dog. All right? You're not going to hold him responsible for anything. You hold whoever gives orders to him responsible.
We're able to enforce that decision.
Well, it's been delivered. All right? In the short term, they've got us outgunned. We can't go in with guns blazing, and we have to respect the power structure here. They've got the power, the physical power.
So you made the decision, the court was in contempt, but you couldn't do anything with it.
Well, he was in contempt of the court. Right. Yeah, that court was in, and those people were in contempt. So we then had a summary judgment, and so now that that's been done, I mean, they've been served with the summary judgment, it's on file, okay? In the short run, they're looking good, they're riding high. But at some point, this has got to crack. They've showed signs of cracking. Yeah, you had a question here. Who's next?
Is there anything different or any reason why I can't, as one of the people of the United States of America, in my court of record, file a claim in federal court against a government, a U.S. or federal agency? Or
well, you could. I don't know what your claim is, but if you find federal rules that they violated, sure. Yeah, be in a federal court. Actually, you can be anywhere. The court of record is the court of the sovereign, not the court of the government. So it's wherever you are. You can do it at McDonald's if you want, but that doesn't put on a good show. So it's better to use the government's buildings. But you could go in a state court, you could go in a federal court, either way.
And I assume that any of the California sites don't apply in a federal court, though, correct?
No, not correct, because the federal government, if there is no federal law, they will use the law of the jurisdiction they're in, whatever state they happen to be in, to cover it. So they'll apply state law in that way. But also, it works the other way. The federal laws apply in the state too. You can invoke federal law in a state court.
So under points and authorities, I can cite the
Sure.
citation about
sure.
The sovereigns don't relinquish their authority to the agencies that serve them, etc.
Yeah, you could say that, sure. The only thing to understand is that, I tend not to mix laws from, into another jurisdiction. You can go federal to state very easily, but going state back to federal is a little more difficult, only because of my ignorance. There are ways that it's applied, but basically
But any federal laws that cover that have to be researched first.
Yeah, you do your research, but definitely federal law applies in the state. The state can enforce it, excepting that my understanding is that if you are trying to enforce a federal felony law, it first must get the okay of the U.S. attorney. You have to go to the U.S. attorney, get his approval to prosecute under that federal law if it's a felony. So,
in your case here, after you determined that the court was out of order or at fault,
speak louder for them.
Pardon?
Let them hear you too.
Well, I'm trying to phrase my question
Uh-huh.
properly.
Well, if you're talking about the importance of it, you see it on
Yeah.
paper, we don't hear it.
If in your case you found them guilty, the judge and the lawyers in the court, then why haven't you gotten a hold of their bond and placed a lien against their bond?
Probably has something to do with the amount of time that's not available and the other issues that I'm fighting and dealing with. And
Well,
so it's all a question of time and knowledge. We have to research it. You know, that's all. We know that those techniques are available, but we have to research them out to do them right.
okay.
We don't have that information. We have the information available, but nobody's reading it, or I'm not reading it. So it's just that's all.
Okay.
It's just ignorance gets in the way. My ignorance.
Okay, but the thing of it is, when we hit them in their pocketbook,
Right.
and if you put something against their bond, then the judge can't act. He can't do anything.
Well, are you familiar with that process?
I'm only vaguely familiar with it.
Well, that's my problem. I'm
Yeah.
vaguely familiar with it. So it sounds like a great idea,
Yeah.
but somebody's got to implement it. Somebody's got to study it, take the time. I haven't done that yet. That's on my to-do list.
That's where we need help in working together and
Well, that's right. And there are some people who have suggested that I follow it, and I've said, well, why don't you study it first? And it hasn't been done yet, so far as I know. Okay, because for some reason they don't have time either. I mean, you know, time is a premium for all of us. There's things that we do, and it takes a lot of time to research and carry out a case. So we have lots of excuses. A little performance there. So anyway.
I was wondering, Bill, when we prepare to move this to where the state is going to actually obviously be a party to this situation, would it be appropriate to write the Attorney General of the State of California and ask him if he intends to validate what his agent did down there in Torrance?
No, what you do is you file a suit in the federal court and you serve a copy on that Attorney General. You don't ask him anything, you tell him. Now he has to answer it.
So when they wanted to make the state of California pay, then that's what that's what the federal court situation is going to bring to his attention.
Yeah, basically, if we sue in the federal court, we will sue the state. He's entitled to a copy. I think that's in the federal rules of civil procedure, that you have to notify the Attorney General of the state that you're suing. I mean, he is their top attorney, and then they put it off to somebody who's an expert on those things. Well, let's see. Let's go back to... Well, I guess we're running out of steam here, unless somebody's got more questions here. I think because...
Did you go over the notice of demand example?
Okay.
Did you actually file that with inferior court on the heading?
Not heading.
Or the...
No, we hit him between the eyes with it. We said, we flat out said they're in inferior court, and we said why.
Okay.
Yeah, we didn't pull any punches in that.
Are you aware of JPs and notarials in the common law?
No, I have information. One of those, it's on my to-do list. That's all I can tell you. Okay, the notice and demand. Okay, basically there's the 8 things in your notice and demand. Okay. Tell him what he's doing or not doing, what your injuries are, his duty to not cause you injury. This is all on the website under procedure. And you state the damages, demand that he in good faith do his duty. If he doesn't do as demanded, then there's tacit procuration. And if he does not performance demanded, you'll take lawful action to enforce it, to defend against him. That's basically what it is.
When you demand a response of receipt in something less than 60 days, you better tell me you're working on it or something, or you just give them a deadline for completion.
Yeah, you just give a deadline. Got X days to answer. If you fail to answer, it means you agree. That's what the tacit procuration is about. Yes.
Do any of the filings like this one need to be a notarized statement or signature notarized? I know.
Well, all a notary does in that instance is say you are who you say you are. That's basically it.
So do you recommend that?
If you want to swear, well, if you want to swear to the truth of something, you can go to a notary and say, that I'm telling the truth. Everything is true there. Raise your right hand. You don't even have to raise your right hand. It's just a customary procedure, but not required. Or, in the alternative, you can make up an affidavit. That's okay. The state says that's equivalent to having it notarized. You declare under penalty of perjury that it's true, the whole truth, and none but truth. Whatever.
An unnotarized affidavit with that statement in it? It has to be an affidavit. Has to be notarized, doesn't it?
No.
Okay.
It's either notarized or an affidavit. It's not both.
Okay.
Yeah. Or
3 witnesses is the same as a notary.
Okay. Sounds good to me.
But a notice of demand can be sent without being notarized?
Yeah,
okay.
But you have to call it an affidavit if you want. What are you doing with a notary? All you're doing in that instance.
Verification of a signature, right? Yeah.
Well, I don't think that's the question. You're not going to, later say that wasn't your signature. All I have to do is ask you. I'm not sure what a notary accomplishes in that context. Now, there's another context where a notary can be useful, only I can't explain it. I don't know enough about it. But that is that you can have a notary send a demand for payment. Somebody owes you something. You've been injured. You can send a demand for payment. Also, if somebody sends you a demand, you can have a notary dishonor it, I think, or send it back. I don't know the details on it. That's all UCC stuff, or UCC stuff. Notarial protest. But I don't know the details. I have information on that I have not yet read. So, we're stepping outside my field of understanding and knowledge. All I have is rumor, like you have. What I know is the immediate court procedures and how to do that, which is what we went into. When you start talking about UCC and you talk about notaries and that, I really don't know that stuff. Even though I'm a notary myself, I haven't taken the time to study it. I've been too busy. There's a lot. There's a lot here. So
you're a notary, not a notarial.
What's the difference?
Notarial is a notary in common law. A notary is under statute law.
Oh, what statute? I've got recognition from the state, so I'm a notary public. Right.
Right.
Sure. All I am, what it really boils down to is I'm a state certified witness. That's what it is. And I passed the FBI investigation.
You have more power than you believe because you are a clerk of a court.
Well, I just admitted that I didn't know that, but I knew there was more. Yeah, you're right.
Yeah.
You understand that.
You have a lot of power.
But I'm not a clerk of the court until somebody sets up a clerk and appoints me in their court. You're not the clerk of anybody's court just arbitrarily. You got to be acknowledged and recognized and appointed.
Well, see, I've heard part of the process. And to check your certification as a notary, you go to the county recorder. The county recorder has you on the list saying you are a notary. Yeah. But then the county recorder, to check out the county recorder, you go to the Secretary of State.
Sure.
So you are under the Secretary of State as a notary.
Right.
Yeah.
And you can check directly with the Secretary of State. You don't even have to check with the county.
No, to get your certification, you have to go to the county.
Sure. You have to register.
Yeah.
Yeah, they don't certify you. You just register. The Secretary of State certifies you.
The Secretary of State certifies the county recorder.
No, and also certifies the notary.
Well, in the process I went through.
You have to register with the county.
Yeah.
That's what I did. I took all the tests. I went through the state. Okay, the Secretary of State handled everything, and then there was one more little task I had to do, and that was go register. And that all you do is you personally appear and say, yeah, raise your right hand, swear whatever, so you're going to do your duties and this type of thing. So it's a serious obligation you take on. So, but that's it. There's no certification on the part of the county. It's the Secretary of State who says, yeah, you passed the test, you have the knowledge, and that sort of stuff. Okay, well, like I said, we're out of my territory in this one, so you're asking me the wrong questions here. What else would you like to cover? That's it? Oh, we got one more.
Well, if there's nothing else, maybe I could ask your advice as to the next steps I should proceed with. Essentially, the city of Bellflower, I think you know about in the background, went after me. We recalled a councilman that was corrupt, and they went after me every year since. So we know why they're going after me. But they tried to do a public nuisance on my property. I appealed it and I won, which makes them hate me even more, because we got the guy who granted me the appeal told them they were being totally unreasonable. Get off my back. They were being a nanny state. He put those words in the...
Do you have a transcript of that?
Yeah, I have his report. Yeah.
You had what you just said on transcript?
Yeah.
All right.
Audio. This was not audio or...
That's all right. You've got transcript.
His report. His final report.
You have transcript.
Yes.
Okay.
No, there's no transcript.
Your next...
report.
All right. Report. You've got it. You got an official statement.
Yes.
All right. The next step is to sue them.
Well,
all right, and sue them for vindictive prosecution.
Yes,
because that's what they're doing. That's the next move.
The next thing they did, though, was they took me to court for a patio that was built in 1954.
Did you do a counterclaim?
I tried and could not figure out a way to do it.
Okay, but that's what you should do. Is you do a counterclaim.
They said it was criminal and a civil counterclaim. They wouldn't allow a criminal counterclaim.
I know. They try to brush you off that way. So look, you're in the county. Here's something you got to understand. In the county, the whole county, there is only one court. You got that? There is no such thing as a criminal court, civil court, and all that sort of stuff. What it is you have one court which has divided the functions up among its different personnel. Okay? There is only one presiding judge in the county. There's only one clerk in the county. There's only one sheriff in the county. Everybody else is deputized, okay? Or in the case of judges, they call them judges instead of deputy judges. But you see, there's only one. So, what you can do, since they want to play that game...
I haven't given you all the parameters yet, though.
Well, somebody done somebody wrong, that's all you need to know.
Yeah, but...
Okay, I mean, all cases are the same. You see, you can give me you can load me up with detail, but the bottom line is, they attack you. You went through the administrative process, they won. You won. Their attack was so bad that even the decision maker pointed out to them how bad they were. Now they've followed up with another action. You now have a basis for vindictive prosecution. They're getting even with you. Okay? So it doesn't matter what they're doing. The point is,
I dredged up on him is even better.
It doesn't matter what they do to you. It's at this stage you now label it vindictive.
Yeah.
Now the thing about the vindictive label is that when you accuse the government of a vindictive prosecution, the burden of proof shifts to them. They have to prove they're not being vindictive. You don't have to prove they are. All you have to do is make the claim.
So you're saying in a lawsuit now or a federal civil suit?
A lawsuit.
Okay.
Just do a lawsuit.
I've got RICO in here. I could go civil.
Choose your technique, but the point I'm getting at is that you have a wrong. This wrong happened to you. Doesn't matter what it is. The point is that they were wrong. Okay? And so now you do, if they have a case going, do a counterclaim. If they don't want to take the counterclaim, sue them in the civil court, just like you would with an original claim. In the heading only, in the body, identify. That's what we did with Aurora.
Well, the court case they just did has now been finalized. What I ended up having to do was a plea bargain with an infraction nolo contendere.
Okay, do the plea bargain if it's finalized.
That's already been finalized.
All right, now sue them in a court of record because
should I try to appeal have them being forced into that corner? Or should I try to do a void judgment before I do the lawsuit?
Do what? Void judgment?
Void judgment.
Well, there's a number of techniques. That's a strategy decision. I don't know enough about your case to make any suggestions, okay? All I can tell you is that you have to somehow do some kind of attack, whether you go at them on a motion for void judgment, or whether it's a counterclaim, or if that's over, just do an original claim. And I would sue them individually, okay? For vindictiveness. And do a property search, all right, which you can do to any real estate, or you can even, actually, you can go on the internet and get
the
property
mayor,
listings.
the councilman, and the people involved.
Well, don't blanket everybody, okay? Pick the people who are specifically responsible that you
But they
know.
were the ones that made the decisions to go after me.
Okay, that's fine. If you know for a fact that they did, if you actually have a record where it was put before them and they decided, yeah, we're going after this guy. All right, what you do is you get a list of their properties, all right, and you go under the civil code. I think it's a civil code, section, I think it's 808, and it's, in any case, look up preservation of interest. That's the name of it, preservation of interest.
Yeah, I couldn't find that before, by the way. Yeah, you mentioned that last lecture.
You do a preservation of interest, and then you file that preservation of interest with the county recorder, and that has the same effect pretty much as a lis pendens. It screws up their credit, okay? Because when you sue them, the basis for your preservation of interest will be your lawsuit. That's a legitimate basis, okay? And if you win that lawsuit, you're going after that property, and you're putting the world on notice that that property is your target if you win your lawsuit.
So do a preservation interest of filing before I file the lawsuit?
No, afterwards. The lawsuit becomes the basis for the preservation of interest. Right, you cannot file a preservation of interest without a basis. Yeah.
Then I just have to find that preservation of interest. I looked all through the civil.
All right, I'll find a moment. But you had a question here next, I think. You have a microphone? Yeah.
Well, it comes up, how do you label the claim a vindictive prosecution?
You just say that here's what they did and it was vindictive. You can speak plain English in a court paper.
So you said that once you file a vindictive prosecution complaint against them, then it's up to them to prove that they were not
The
prosecuting.
burden of proof is on. You're going to have to do some research, but I have seen that at some point I remember reading a case about vindictive prosecution, and they said the burden of proof shifts to the government whenever you raise that issue.
To prove they were not vindictive.
They have to prove they're not vindictive, right.
They have to prove a negative? That's impossible.
That's exactly right. Pretty tough problem, isn't it? They have to prove they were not, okay? So, let's see. I think I can give you. I'll get that section for you here in a moment. It's listed here. Let's see. We have there it is. Here's the preservation. Okay. This is the actual form that we put together in accordance with. If you look up the code, and it says right here, you got it here, I know.
88, right there.
880?
Yeah, 880.020.
Where I still don't see it.
Notice of intent to preserve, okay? 2 lines.
There it is, 880.020. Okay. Yeah. This is the civil code, okay? Civil code covers marketable record title, and yeah, it's section 880.020. You put a preservation of interest. See, the thing is a lis pendens is what attorneys use, and apparently the clerks or the county recorders have been instructed to only accept a lis pendens from an attorney and not from an individual. But they cannot lock you out of the process. So they have another provision called preservation of interest, so that you can let the world know that you've got a dispute going on, and this property is subject to attachment. So once you get that filed with the recorder, the world has been put